Welcome to the University of Michigan Dentistry Podcast Series, promoting oral health care worldwide.
I'd like to introduce Dr. George Payne, a clinical professor of orthodontics at the University of California, San Francisco, and a private practitioner in orthodontics in Santa Rosa, California. George, how are you today?
I'm fine, Jim.
George is a very unique individual for an orthodontist because he's had quite an experience in the insurance industry, and he was on the board of directors and actually for some years a vice president in charge of underwriting for the Dentist Insurance Company of California. Is that right?
That's correct, Jim.
And also, he currently serves on the Legal Advisory Council of the American Association of Orthodontists. Now, we have, especially over the last few years, have seen a tremendous interest in the orthodontic community regarding malpractice suits, unfortunately for reasons of occurrence. And I'd like you to talk to us today about the process of how a claim is filed, what goes on, how expert witnesses are picked, all the things regarding a claims situation.
Okay, Jim, that's a good topic because I think largely the orthodontists and dentists in general don't understand really what the mechanism is that occurs when you have what we call an incident. That's how it usually starts. You may have a patient walk out of your office displeased. You may receive a 30-day or a 90-day summons. Any one of those should alert you to the fact that you should call your carrier. That's your first responsibility under your policy in any insurance company is to notify your carrier. When that information reaches the insurance company, a claims adjuster will be talking to you and will ask some pertinent questions. That individual, because of their experience, have to make a judgment call when you make your phone call about the classification of that report you've made. Does it become an incident? An incident is something an insurance company regards as just that, a single incident which may have had some downside risk in your eye. Nothing may ever happen. The insurance company just files that without establishing what's called a reserve against that incident. Only when that switches to a claim. Now, if you call in and tell the claims adjuster that you've received a summons, a subpoena...
What's the difference?
Okay, an incident might be just the first thing I alluded to, where Mrs. Jones walked out of the office and said, Dr. McNamara, I'm going to sue you, or I'm really upset with what you did with Susie. So you're feeling pretty badly and you think your chances of receiving notification are good. You call the insurance company and put them on alert. Okay. They will then tell you to take certain steps. Open a separate file so that if any correspondence comes regarding that case from them or the attorney, it doesn't occur in the patient file, things like that. Now, if you do in fact get a summons, which means you're being sued, then the insurance company moves that to a claim. That then becomes a claim. They know that they're going to pay some money because they have to, at the very least, write a letter to answer that claim. That claim then has a reserve established against it, and that reserve is the dollar amount that the company thinks it will take to settle that claim. And obviously, that's a very complicated process, and it goes, claims escalate in reserves as they move along. The next thing that might happen would be you'd receive a request for records. You would then copy your records, never send out your original records, copy your records, supply the records that are necessary. The insurance company may also ask for a set of those records. You will go ahead. You had a question.
Let's say that you have, as I do, a treatment plan that is cryptic, as opposed to, I might say CEO with TPA, which tells me exactly what I'm going to do. At that point, can you supplement your records?
Yes, you can.
You can, so that you could provide a written summary that you wouldn't do on every patient, but that you could clearly do for the purpose of the
That's
evaluation.
right. As long as that's dated with the current date that you wrote it, and you make it clear that you are making a recapitulation for the edification of whoever has to read it and can't read your encryption, that's perfectly good.
As long as it's dated the date.
As long as it's clear to anyone who reads it that there's no attempt being made to have that as a substitute for what was originally written.
Okay.
You follow me? In other words,
Sure.
it has to relate to that date. The same would occur if you had an entry in your chart and you then thought about something later on. You remember that Mrs. Jones said something as she went out of the room, but it's the next day when it occurs to you. You don't go back and try and cram it in. You go down to the next line, enter today's date, and say, regarding Susie's appointment of such and such a date, I have just recalled that Mrs. Jones made the following comments. That's the correct way to do that and protect your records from attack as being possibly falsified.
Okay.
All right, the insurance company now has your records, and a reviewer is going to look over your treatment record and a form you will fill out which tells them how the event occurred that you think you're being sued for, a lot of background information. That claims representative then may contact you and talk to you about it. There's a judgment made within the company about what we need to do next. Shall we just sit back and wait for the plaintiff's attorney to take further steps? Years ago, that was a standard mechanism in liability companies that were defense-oriented. Nowadays, because of the bad faith litigation, it's incumbent upon insurance companies to make what's called a good faith effort to settle a claim.
We don't have bad faith litigation.
Okay, then you don't need to worry about that.
What is it exactly?
What it pertains to is that if there is any indication in the patient's chart or any of the material that you've collected that there's some liability or culpability on the part of the insured, then the insurance company by law has to make a good faith effort to say we will pay X number of dollars to settle this claim on that basis. In the normal course of events, a large number of claims would never go any farther than this stage. There'd be some exchange of records. The plaintiff's attorney has to go out and have a certification by, at least in California, by another practitioner that there is in fact merit to his case, called a certificate of merit.
Okay.
Unfortunately, if you're a JD and a DDS, you can sign your own certificate of merit, so it doesn't have a lot of weight. If, after reading the case over, the plaintiff's attorney says there's no case here, then that's the end of it. If he thinks there's a chance that there's some recovery available because of some possible liability on the defendant's part, then the two sides enter into a process of either taking depositions of each other's people and further discovery, as it's called in legal jargon, until you get to the point where some demand is made in a dollar amount by the plaintiff and then answered by the insured's company, and usually the case is resolved. About 90% are resolved. Now, if that doesn't happen, if somewhere along the line it becomes clear that the case is not heading toward settlement, the defense counsel becomes active. The defense counsel should have, at the very first thing always, contacted the insured. And it's very important for the insured to understand that that attorney represents him, not the insurance company. He has, even though he's chosen by the insurance company, his primary obligation is to the insured, to the dentist insured.
What happens if the defendant feels that the defense counsel is not adequate?
He should communicate in writing that fact immediately to the insurance company and demand new counsel.
Could I name somebody that I...
You could. The insurance company it's not incumbent upon them to accept that. They get to choose the defense counsel. Now, you can hire your own independent counsel, and many times that's a good idea, provided they have some expertise in the matter. The same man that drew up your will or helped you with your last escrow is not the one to have. You would need to seek out someone with greater expertise. And in very complicated cases, the insurance company would often recommend to you that you have your independent counsel. The duty of in our view, in our company, the duty that we want our defense counsel to perform is to immediately do what we call hand-holding. And that's to go to either contact by phone or even preferably physically appear at the office of the insured, explain to them the process that I've just explained to you so that they're comfortable with what's going on. Keep them fully informed. And this is where the system breaks down very often. Things happen, 3 months go by, and the dentist doesn't hear anything. And he's wondering what's happening. And because of the pace of the law practices and things, they're not doing, in my view, as much of that as they should. I think that's the weakest part of, at least in our program. The attorney then would prepare that defendant. If a deposition had to be taken, he would spend the time to go over the whole record with the defendant and read every single line with him and make sure he recalled all of the abbreviations and knew exactly what he'd written on there, all of the events, cover all of the possible questions that he might think would come towards his insured from the plaintiff's counsel. Then they go into the deposition. And both attorneys are present at that deposition, and of course that's becomes part of the trial record. And the same thing would happen if the case went on, then further even into trial. The defense attorney's job then again is to sit down with the insured and prepare him or her for the trial just as he would prepare his expert witnesses. He has to go out and select the people he thinks have the most knowledge in the field in which this particular case rests on. The ones that are most credible will have the best rapport with the jury. As we talked earlier, it has a lot more to do with just the fact that you are an expert in the field. And that's a very, very important job of the defense attorney, is to pick that person and school them very well, make sure they have read everything there is to know about the case, talk to them about the points that they want to bring out, things that they want to stress, and the possible lines of attack and how to minimize their exposure from the plaintiff's side.
Now, if the defendant or the expert witness is being deposed by the plaintiff, under what obligation? First of all, this is not an examination, cross-examination kind of thing. It is the opposing attorney asking you questions that he probably will ask you, or at least some questions he'll ask you at the trial. Under what obligation is the defendant or the expert witness for the defense to volunteer information, what is the recommended approach for someone who is being deposed?
Well, generally speaking, when you're being deposed is much like in the trial, and I'm certainly no lawyer, but usually the caveat that's given is that the less you can volunteer, the better you are. You want to answer the questions directly and truthfully without volunteering ancillary information. You don't owe the plaintiff's attorney in a deposition an explanation. You answer yes or no or I don't know. That is a lot of dentists don't want to use that. They feel they're compulsive in that regard. It's perfectly correct if you don't recall or don't know, to say, I don't know. The plaintiff's approach, of course, is to open every possible avenue that he can through the process of discovery and also through the process of examination, cross-examination if it gets to the trial. So therefore, the less opportunity that the defense gives him, the better off that is. And that comes about by being very careful to answer the questions in a direct and straightforward manner with volunteering as little information or no information if possible. But also to be cognizant that the jury is observing that expert witness very carefully and how he acts or she acts and reacts. And there has to be a believability quality. So you don't want to, I guess, just be the stonewall, but it's a skill not unlike any other skill that people develop. And to watch a really good expert witness testify is a very interesting thing. You get a sense that that I knew was different than what I expected.
Now, let's assume then that we have finished the deposition, the gathering of all evidence and so on. Then is the next step mediation or a mediation board where they make some recommendation as...
That may be. There's always what's called a mandatory settlement conference. And the MSC is where the judge calls the two sides in and attempts to resolve the issue the last time before it goes to court. That's a way of unclogging our court calendars. And at the mandatory settlement conference, you have to be able to respond to dollar values that are going to be put forward. And the judge is going to ask, do you think that's reasonable, or what's your offer? And not a lot of cases are settled. They're either settled before that, generally, or they get settled at some later date. It's not uncommon for them to be settled while a jury is still out.
Oh, is that right?
For a settlement to be reached. In fact, one of the largest malpractice awards ever by a jury in California, I forgot, I think it was a $1.6 million verdict on an implant case, was settled about 15 minutes before the jury came in for $400,000. The plaintiff's attorney had taken a reading of his view of his impression on the jury, and I think he felt insecure, and so opted for the settlement.
Okay, now so the next step then, after they decide whether they're going to settle or not, is to go to trial, right?
That's right. Yeah.
Now, what sorts of things is it incumbent on the defense counsel to do in preparing the defendant and the expert witnesses for the case?
Well, you move now into a whole different arena, because up until this point it's been fairly straightforward legal procedures which are pretty well codified, and we know exactly what we have to do. Now, when you get into the trial, you've moved into an arena where things are staged. You really stage your performance almost. You've watched how opening statements are made by trial lawyers, and they have specific goals in making that opening statement. They have to think ahead and plan. Is there an emotional appeal I can make? Where am I going to emphasize my defense or my attack? You have to school every single person that's then going to sit in that witness chair. You have to, you almost have to tell them how to act as if you were going to a play. They need to project a certain image that you want them to project as best you can get them to do that. You want them to answer questions in a certain way. You want to make sure, again, that they don't volunteer things. You want to be sure that you have taught them that. You want to prepare them for every possible conceivable question you think they might get from the other side, so that you can then help them frame an answer beforehand, so that they're not sitting there on the stand not relating to that question.
You made a statement before about the fact that you have to be very careful about what you say to the jury. And what does a lawyer assume the jury represents? You know,
jury selection is, of course, trial lawyers, I think, would agree, the key to successful practice, they feel. That's their ability, and that's called the voir dire process, where they get to examine people, and they get so many opportunities to dismiss and for cause or preemptorily. They want to pick the people, and they have demographics. They hire firms, Jim, who give them profiles on different groups of people, so they know how they vote, how they act, how they think, what their perspectives are on given problems. And they use that material when they're looking at prospective jurors. They know which ones have certain sympathies or certain feelings. They will strive to pack that jury with the type of people that are going to have the most favorable view. Now, they know some general things that all trial lawyers know. For instance, the average educational age of the jury in the United States, I think, is about the 7th grade, something like that. So they know that going in. So that tells them right away what kind of vocabulary they need to be using. You right away sense a difference when you talk to your defense counsel or you listen to the plaintiff's counsel in a deposition and he's talking to you or to one of his peers, and when he gets in that courtroom, you suddenly hear a whole different vocabulary because he knows how important it is that no technical jargon be introduced, that everything be in terms that that jury absolutely understands. He doesn't want to, neither one of those attorneys want to have any situation where one of their people is saying something that the jury doesn't understand. In fact, they will often interpret it. They will say, well, doctor, you really mean, and they'll do that because if we slip as witnesses and use our professional jargon, which we're wont to do, they will very shortly pull us up by reminding us subtly like that. It's very, very important. You can imagine how quickly a jury would get bored listening to two dentists just talk in dental terms. They don't understand it. It doesn't make any sense to them. So that's a tremendously important part, and that's the defense counsel's job, is to see that that occurs.
Okay, now, what else do we need to know about this? What other aspects?
Well, I think we need to know that from the insurance company standpoint, the insurance company is there basically to help and support the insured. And I'm very uncomfortable when our insureds feel that that isn't the case. There begins to be some kind of antagonism. They feel the insurance company is not really representing them. I think, I can't speak for all insurance companies, but I can speak for ours, and that is that the dentist's interests are always primary. We do require that they cooperate with us, and that means that they have to provide us with all the information, and if there's any information withheld, of course that's really damaging, particularly when it may turn out that through some other channel a plaintiff's attorney has already found out that information. So I think it's a question of mutual trust and respect between the two, and what it does more than anything is reinforce in our minds as insureds that maybe we haven't been doing everything in our practices that we could have done to have protected ourselves.
It seems to me that one of the critical factors is the quality of the defense counsel. And that seems to me, at least with my experience, especially in the last year, where I've been involved with a number of different defense counsels, that you'll find that there are some, quite honestly, there hasn't been anybody as knowledgeable as some of the plaintiff attorneys. And they obviously have much more to gain, and they are not afraid to put in the work if that could be a benefit. But there's a wide variety of experience of people who have some passing knowledge of some of the things that we deal with as orthodontists, TMJ things, for example. But there's a big variety of actual, below the superficial level, when you get down into the detail and so on. What can the dentist do, or the orthodontist do in this respect?
Well, it's very difficult because when you're the insured, you're relying. Let's face it, most of us haven't had a suit before, and this is a new experience. You're relying totally upon the insurance company, and you don't have a way of judging unless you get somebody else to make an evaluation of the person assigned to you. If you don't perceive that they're well enough qualified. Most insurance companies go to rather great lengths to employ firms or people in firms who do a large percentage of defense work in the medical field, even to some subspecialties in medicine and dentistry. The firms that we use tend to have one or two people that, even though the whole firm handles some of it, there are usually one or two people who do nothing but the dental malpractice defense work. That's all they do. And that's the kind of person that you really want, and you shouldn't be afraid as an insured to ask for the track record. It's no different than than buying a dozen eggs. You want to know how long those eggs have been on the shelf and how good they are. If you're going to have a defense attorney represent you, there's no reason that you shouldn't ask for his qualifications just as a patient might ask for yours.
Sure.
And you need to satisfy yourself that you are, in fact, in the hands of someone who understands what his or her responsibilities are and can competently carry the case, particularly when it gets to trial. There are a number of firms with good people who do all of the paperwork very well and can handle everything and do the negotiating for the settlement. But when you get to the trial phase, you may want someone else to actually handle a trial phase, and in some firms there is or are people who specially do that.
Well, you know, that same sort of logic may also apply to the question of the expert witness, because so far I have had experience in about 9 or 10 cases where I've had or have been asked to give an opinion on whether there was a problem or not and what I thought of the case. And it seems that there's a very real difference between let's say if I were a defense counsel and I would find an orthodontist, and I mean could be anybody in private practice, who could review records to see whether, based on their understanding of the standard of care, that these were things that there's something wrong or there was not. That seems to be a totally different arena than if you are asked to perform as an expert witness. And I think that, quite honestly, especially with my experiences in the last year of having been involved as an expert witness in a case that went against the defendant, and you know, my attitude in that whole thing was that I was going to go in, and even to this day, I have no regrets regarding what I did. I was more regrets of some of the things I didn't know about at that time. Yeah. But the question of saying, you know, for example, I've heard any number of people, orthodontists that are not associated with the university, have said, oh yeah, I was an expert witness in XYZ case. I think today that the rules, the players have really gotten a lot better, and that it probably would not be a good idea to have someone who was in private practice down the street from somebody to go in as an expert, but to really take all these cases seriously. Because in the case that I was alluding to, no one thought that we were going to lose. And so therefore, it's like going into the Super Bowl with a 50-point favorite. There was no question that this case was all right, and there were some things that clearly influenced the jury the other way. But you know, I think that the role of the expert witness is such that I would be very reluctant to agree to do that unless I were very knowledgeable and had good credentials. And even in the case where I am reasonably knowledgeable and did have good credentials, it still didn't work. So it's something that I think it certainly gives one pause for concern.
There's definitely a dichotomy between serving as a reviewer for an attorney who calls you and says, I have this file and would you look at it and do you think there's any merit to the case? There's a great deal of difference between our roles in performing that function as opposed to being expert witnesses, because there's a whole lot of different skills required in the second that aren't required in the first. In the first, only good academic, clinical background, reasonable common sense are necessary to do that. You need to be able to make an independent judgment about whether the standard of care was breached. And you can either do that or you can't from the records that are giving you, and you're going to tell the attorney one way or the other. Now that's a whole different ball game from being an expert witness, where you, in essence, become an advocate.
Right.
You're placed in a position where you have to use your expertise for the best defense that you can make for the person that you have been hired for. And
well,
that is a whole different genre of person that take to that, enjoy it, and do it well. I would submit that probably any of us could do the first thing, could review the claim and look at it. I think not all of us would be good expert witnesses.
Well, one of the things that really frightens me about this is the fact that in the cases that I've been involved with, as a reviewer of records and also as a potential expert witness, I have been the person who has sort of insisted that Dr. X or Y be called in as an expert witness, because the defense lawyers were willing to take really sort of the orthodontist in the street as opposed to someone who really has strong credentials. And I think this is one part where I know there's a movement afoot within the American Association of Orthodontists of getting a panel of expert witnesses and so on. But I think one thing that should be made very clear, that anyone that acts in the role of this, that you're taking on a 40 or 80-hour job.
Yeah.
This is not something that you casually do at the end of the day before you go home. I mean, this is an incredible amount of time that's incorporated in serving as an expert witness.
That's absolutely true. It is a big job, and we are developing a panel of people, I think, who can serve. And you know, Jim, even if they don't actually take the stand, because a number of times a defense attorney will have a number of people that he uses as defense witnesses who have what we would call the role 2 characteristic of the expert. Can talk in simple 2-syllable words, has the folksy approach, and doesn't give the opinion to the jury they're being talked down to. Now, what we can use our experts for is often to bolster those people's ability, because it isn't the absolute credentials. The layperson already perceives that people in the medical and dental profession have so many credentials that they can't keep track of them anyway. But if we could assemble a panel of people who would be available for defense attorneys to utilize for their expert information in helping develop the case, not necessarily to put them on the stand, but to say, is what that guy's saying, is that really right? Is that what the standard is? Is that what the outcome would be expected of that kind of treatment? What is your experience in that? And then if they can parlay that into their favorite person, then you probably have the best of both worlds.
Yeah. Well, is there anything else you'd like to add to this as far as your experience with the insurance company or your experience with the AAO?
I don't think so, Jim. Maybe just to say that I really think that we're on the right track, that developing risk management programs for orthodontists is something that should have been done some time ago probably, and that this is a clear benefit of membership in the association, and I'm pleased that we're moving in that direction.
Okay, thanks, George.
Thank you, Jim.
You've been listening to a presentation from the University of Michigan School of Dentistry, which is dedicated to supporting open learning and open educational resources. This recording is licensed under the Creative Commons. It may be reused and redistributed for nonprofit use. Please attribute materials to the University of Michigan School of Dentistry and redistribute under this same license. For more information on how this and other University of Michigan School of Dentistry recordings may be used, visit www.dent.umich.edu/license.